Patrick Bush, with the Legal Counsel Division. I will just reiterate, I really like it when people at CLEs ask me questions. Otherwise, I have to talk for the entire hour. So again, those of you in the room with me, please, if you have any questions for me, ask them. Those of you on the webinar, please send them in by chat and they'll be asked to me as well. Those of you in the room, you'll notice there are some mysterious, I can't tell if they're blue or green lines. Those are not part of my presentation. I'll just ask you to ignore those. They're mysteriously appearing. It's technology at work for us. So topic for today, recent court rules amendments and recurring issues. There we go. I'll start with the recurring issues. We in state court administration, our clients are court administration staff from all over the state, as well as court employees and judges within this building. And we do see we hear from court administration staff, there are some common errors that attorneys make and sometimes judges and law clerks can make, and they result from a lack of attention to court procedural rules. And we've seen those consistently since the court's transition to electronic filing in 2015. And so I'll talk with you about some of those common errors, and a lot of them relate to public accessibility of court records. I'll also talk with you about which court records are public and which court records are non-public. In terms of court rules amendments, I'll talk with you about the new timing system that went into effect January 1st of 2020. And I'll also talk with you about the new rules relating to transcripts of audiovisual exhibits that will go into effect March 1st, which is, I believe, just next week. Then I'll talk to you also about some pending rules proposals the court is considering, and finally I'll get into the very interesting concept of service contact clutter. I'll save that one for the end. So, I'm going to talk with you about, I talked about errors. A lot of these errors, they really are avoidable and they result from a lack of attention by attorneys. This case I have up on the screen is a 2019 Court of Appeals case where Court of Appeals dismissed an appeal for lack of jurisdiction, and the issue, the attorney wanted to appeal the district court's ruling. It was a family law case, things like custody, I think parenting time, spousal maintenance, issues most of us would consider quite significant for the client. And the attorney had completed all of the appellate documents within the time frame, but then I believe that they waited until the last day to actually log into Emacs, the appellate e-filing system, in an attempt to file the documents. And when the attorney staff did that, they discovered they were unable to sign into Emacs due to a forgotten password. And on top of that, they couldn't reset the password themselves because they no longer had access to the email address of record. So when they clicked the forgot my password link, went to an email address they didn't have access to. And so as a result of that delay, the appeal was not timely filed. And so then the Court of Appeals did what it does in these situations. It issued an order questioning whether they had jurisdiction. And the attorney says, well, yes, this appeal would have been timely filed absent the computer problem. And I quoted that from the attorney's filings. Well, the Court of Appeals didn't agree that this was a computer problem. The issue was the attorney had not kept track of his password, and the staff had not kept track of the password. And so the result was the appeal was dismissed since Emacs, the system itself, was operational at the time staff attempted to file. And again, this error, it could have been avoided if the attorney had exercised diligence with making sure that he had access or his staff had access to Emacs. Again, the arguments that the attorney made were not, it's not a viable defense under the rules since Emacs was in fact operational at the time they attempted to file. This errors are avoidable. This is, I've actually never used this in a CLE before. You guys are the first ones to get this example. This is from February 17th of 2020. It's from our counterparts over in the U.S. District Court for Minnesota. The screenshot is on the screen is from an email that the clerk of the federal court sent out to all people who are registered to e-file with the U.S. District Court for Minnesota. Issue was that they had discovered attorneys had attempted to redact documents they filed with the court by just putting black rectangles over the information they were trying to redact. And I think see a couple people in the room laughing. I would hope by now most people know that is not an effective means of redaction. Member of the press discovered this issue. Never a good thing when it's the media who discovers things. Really, attorneys, we should be discovering these things ourselves. that this is not an effective means of redaction, and so as a result of this, the federal court is now having to go through their filings that were redacted by filers and look to see if they were in fact redacted appropriately. And this is something, incidentally, for state court, we do a very clear guidance to filers. Make sure that if you're redacting things, we use a specific example, do not put a black rectangle over it, because in an electronic document, you can delete the black rectangle. So those two situations, they could have been avoided if the attorneys involved had been on top of the court rules. So for the first example, there are court rules requiring you to, attorneys to keep their usernames and passwords up to date. And for the second example, state courts, like the federal courts, do put the burden on the filer to keep non-public information out of public documents, and if you're going to do redactions, to make sure it's an effective means of redaction. And so a lot of these issues that we've seen, they do relate to lack of attention to court rules. There were some wide-ranging amendments to Minnesota state court rules in 2015 to facilitate the transition to statewide electronic filing. If any of you have worked in the area of juvenile protection cases, you'll know that the juvenile protection procedure rules were completely rewritten in 2019. That was an effort to simplify the rules and make them more consistent with some amendments to the Juvenile Court Act. I'll talk with you in some detail about the new timing and exhibit transcription rules adopted in 2020. And also there are other proposals under consideration that, if they are adopted, all attorneys will have an obligation to familiarize themselves with. Areas where we do see some issues, and again, these are procedural issues, has nothing to do with the merits of the case, but they do apply to all e-file documents. So all documents attorneys file, those are General Rule of Practice 11, which is the rule dealing with submission of restricted identifiers to the court. General Rule of Practice 14, which is e-filing and e-service. And then there are the rules of public access to records of the judicial branch. So at this point in CLEs, I usually ask my audience, how many of you have read the Rules of Civil Procedure? And most people have. How many of you have read the General Rules of Practice? Again, most people have. How many of you have read the Rules of Public Access? Show of hands. All right, all my colleagues in the back there, thank you for raising your hands. All right. It used to be when I gave these CLEs, everyone knew the Rules of Civil Procedure, everyone knew the General Rules of Practice, but fewer people knew the Rules of Public Access. So I'm glad to see so many of you raise your hands. The punctuation mark I have up on the screen is called an interrobang. It is a combination of an exclamation point and a question mark, and still too often it is the reaction that I get from attorneys when I talk about the public access rules. But I think, as most of you know, they are the rules that govern access to all information held by Minnesota's courts. Most of Minnesota state government is governed by the Chapter 13 Minnesota Government Data Practices Act. But once information comes into the possession of the Minnesota Judicial Branch, it is governed by the rules of public access. And under the rules of public access, the presumption is that everything that's filed is public, unless there is a specific legal reason why it is not public. And so you should assume, this is more of an issue, I think, for attorneys representing external clients than it would be for judges and law clerks, but it's something that judges and law clerks need to be aware of. Assume the world will see everything filed with the court. A lot of confidentiality laws just don't apply to court filings. So, for example, some of the provisions, well, none of the provisions of the Government Data Practices Act apply to court filings. One of the things we get often from external filers, things like HIPAA governing medical records, well, that doesn't apply to court records. That applies to your doctor's office, your health insurer, but not to court records. FERPA, another privacy law relating to educational records, does not apply to court records. And so for filers, if they're asking to make something confidential, or if a judge wants to issue an order making something confidential, there does need to be a specific legal basis to make whatever it is confidential. What is non-public? Well, Public Access Rule 4 lists the specific types of case records that are presumptively non-public. Now, under the public access rules, trial courts do not have the authority to issue standing orders limiting access. Only the Supreme Court has the authority to issue standing orders limiting access. However, trial court judges can issue protective orders limiting access to records that would otherwise be public on a case-by-case basis. But when they do so, they need to make findings that are required by law, by court rule, or by case law precedent. Now, what those findings are going to vary based on the case type and also based on the document type. So, for example, under common law, under Minnesota common law, there's one standard for civil cases restricting access. There's another standard for restricting access to criminal cases. Under the rules of juvenile protection procedure, if you're in a juvenile protection case, there is a separate standard for restricting access to presumptively public access to records in a juvenile protection case. And so, again, when I advise external attorneys, I say that you need to, if you're going to ask for a protective order, you need to make sure that you know what the applicable standard is and you have a basis to justify the application of that standard in this case. And for judges, for law clerks, if you are going to be issuing an order restricting access to otherwise public case records, you do, I mean, as with all orders, you want to make sure that you have a sufficient legal basis to support the order. Another example we often use in CLEs is the divorce of the late-grade artist known as Prince, who was divorced in the Hennepin County District Court by the Hennepin County District Court in 2007. And the reason we bring this case up is stipulation of the parties is not a basis for confidentiality. At the time, and understandably since one of the parties to the divorce was a very well-known celebrity, the parties sent the court a stipulated proposed order to seal all records of the dissolution, and that was signed at the outset of the dissolution proceeding, as was, I believe, a common practice at the time by that court. And so the parties go through their dissolution. They were able to negotiate a relatively amicable resolution to the dissolution, and so the case was resolved based upon the parties' negotiations and based again upon that stipulated proposed order that was signed by the court. All of the records were sealed. Fast forward to 2016, Prince passes away, and a little-known newspaper called the Star Tribune petitions for access to the court records. I'm being sarcastic about little known. And I know, understandably, the surviving ex-spouse objected very strongly to these records being made public because they did have a lot of detailed personal information like monthly budgets, how much spousal maintenance may or may not have been awarded, details of property holdings, all those kinds of things that the spouse understandably did not want to be made public. It was both sides were represented by experienced attorneys. They argued it at length before the district court, and ultimately what the district court said was that there is no basis for this order sealing the court records. And so because there's no basis for that order, the records should be unsealed and they should be made public. They were made public. They were reported in some detail by the Star Tribune, and you can read them today, as can any other member of the public. Another issue, we get a lot of questions about this, especially from court administration staff as they are processing documents. It's very common that court filings, especially state court filings, will have a lot of sensitive personal information. Again, sensitivity by itself is not necessarily a basis for confidentiality. The example I have up on the screen is the identity of a child victim of sexual assault. Now, let's say there's a criminal sexual conduct charge brought, which often there will be in that situation. In that situation, in the criminal case, in the criminal sexual conduct case, the child's identity is non-public. The child might be referred to by initials and year of birth. And that's because Public Access Rule 4, Subdivision 1M specifically says that in that type of case, child's identity is non-public. Let's say there's also a related juvenile protection case brought, again, based on sexual assault. At that point, based on the applicable provision of the juvenile protection rules, the child's identity is non-public in the juvenile protection case. But let's say, and this sometimes happens, that maybe the perpetrator was a family member, and then there's a custody matter brought, maybe a divorce or an order for protection case. Well, in all of those cases, the child's identity is presumptively public because there's no legal basis in those cases to make the identity non-public. And so I use that as an example of how sensitivity by itself is not a basis under the public access rules to make records confidential. Another area where we get a lot of questions from court administration staff and from attorneys. What medical records are public, what are non-public? I think you can see on your handouts, the difference is between medical records and medical information. Medical records themselves, and this is under the current rules of public access, are non-public. Medical records defined, I've summarized the definition on the slide, full definition is in the rules that are from medical, healthcare, or scientific professionals that relate to an individual's health or genetic information. So it's a two-pronged definition. It has to be from the medical, healthcare, or scientific professional, and it must relate to an individual's health or genetic information. This is similar to the definition under Minnesota's Health Records Act. And so if something is a medical record, let's say it's a psychologist report or some other record from some sort of a medical professional, then it is, and it relates to an individual's health, then it's a non-public record. However, medical information taken from that same record is presumptively public, and the key here is Public Access Rule 4, Subdivision 4, that any party can include information from non-public documents in public court filings as long as it is necessary and relevant to the issues being addressed by the court. So think about, again, one of our hypothetical family law cases, maybe someone's mental health is an issue or their physical health is an issue. Maybe there's a psychological evaluation or a physician's evaluation that gets sent to the court. That would be non-public, but if that's been filed, either party is free to quote from that information in public court orders or public court filings, and certainly the judge has discretion to include any of that information in his or her court orders. It would again be presumptively public.
We have a question from the webinar. Person asks, do the court clerks monitor what is submitted to look for things that should not be released, like medical records, or things clawed back after it is discovered that they were released?
So just to make sure everyone hears it, there are two parts to the question. Do court clerks monitor for filings for information that should not be public, and if it's discovered after it's filed, does it get clawed back? So the first part is court administration staff, under the rules, they are not responsible for monitoring filings for non-public information. If they do see something non-public, they will take action. They will restrict public access to it. I'll talk about a pending rules proposal related to that later on in the presentation, but I think the figure right now is district court staff process roughly 1 million documents every month. They simply don't have the resources to screen for non-public information. So the court rules are very clear that the responsibility is on the person filing the document to keep non-public information out of public court filings. And then for the second part, are filings clawed back? Once court staff have accepted a document for filing, it is in the court file. It's not going to go anywhere. But again, if they do notice some non-public information in a court filing, they do have the ability to increase the security of the. It's called increasing the document security, which means restricting public access. So in terms of responsibility, this, I have what could go wrong written up on the slide. As an attorney, I tend to gravitate towards what could go wrong, and this is an example of where things went very wrong. It's related to the question that was just asked. It's taken, this is a U.S. District Court for Minnesota case from 2010. Now, federal court rules, similar to state court rules, do put the burden on filers to keep non-public information out of their public court filings. Situation in this case, I've got the full site at the bottom of the slide if you'd like to read the case. It is worth reading. The judge goes into detail about the reasons why she sanctioned the attorney. Essentially what happened was, for whatever reason, the attorney had filed a lot of documentation that had lots of people's full names and social security numbers, which is a issue there is that it puts people at risk for identity theft. The judge brought this to the attorney's attention at a court hearing. It's never a good thing when the judge is the one bringing your errors to your attention. And so the judge brings it to the attorney's attention. The attorney says, I apologize, Your Honor. Thank you for bringing this clerical error to my attention. I'll get that fixed right away. A few hours later, the attorney refiles the document. And again, this is 2010. This is 10 years ago. Attorney made the same mistake as I mentioned earlier, where they just put black rectangles over the document, over the non-public information, which in an electronic document, you can just delete the black rectangles and look at the information. So and again, this is 10 years ago, but even then, the judge found that to be a basis for sanctioning the attorney. Sanctions included having to notify every person who was affected by the filing, to offer each of them, I think it was a year's worth of free credit monitoring at the free to them credit monitoring that the attorney had to pay for, I believe a $300 donation to a local food shelf, and was also required to personally appear in front of the judge in 10 days' time to advise the court as to the status of compliance with the order. Language I have here, it bears repeating. This is language from the federal judge. The days of attorneys being able to ignore the computer and shift blame to support staff in the event of an error are gone. The consequences are simply too serious. It is the responsibility of counsel to ensure that personal identifiers are properly redacted. So in this respect, that is the filer's responsibility to keep non-public information out of public court filings. State court rules, federal court rules are very similar. State court judges have the same discretion to sanction attorneys for non-compliance as well. And so certainly in this area of electronic access, of on-demand access to documents, it really is it is very important for all filers to make sure that they are complying with their obligation to keep non-public information out of public court filings. I have a slide here on the mechanisms for e-filing non-public information. What you have in the center of the screen, this is what district court filers see every single time they file a document. The system requires them to fill out a filing comments field, and we have text in that field. Is document public, confidential, or sealed? And so I think often for attorneys, it's support staff who actually do the process, who actually process the electronic filings, and so they're the ones who enter the information into the field. But the system does require them to designate everything they file as public, confidential, or sealed. In terms of the terminology, there is a difference now between confidential and sealed. They are both legally defined terms in General Rule of Practice 14. Confidential just means that the public doesn't have access to it. Sealed means it's so sensitive that even most court employees don't have access to it. Why is this an issue? Why do we bring it up in CLEs? Well, sometimes district court staff will get proposed orders or motions saying we want to make these documents confidential and sealed and inaccessible to the public, and sometimes we'll have usually it's a proposed order that a judge signs saying these documents are sensitive and shall be confidential and sealed and inaccessible to the public. The trouble for court staff is, well, what do we do? Do we make it confidential or do we make it sealed? And I bring this up to highlight that the terminology is that there are some differences in the meaning of those two words. For those of you who are law clerks, if you're drafting orders to restrict access, please be aware of the fact that these words mean two different things. Again, as I said earlier, for filers, unless a specific rule authorizes non-public filing, there needs to be an order making the filing non-public. If you're a law clerk drafting an order to restrict access, make sure that you have a specific legal basis to restrict access. And again, in general, filers can quote from non-public information in public court filings. So that's about all I have on public access confidentiality before I move on to the new timing system. But does anyone have any questions about public access? Yes.
So that the Data Practices Act doesn't apply to judicial records.
That's correct.
Is it fair to say that the public access rules serve the role that the DPA serves for other branches?
So for those of you on the webinar, the questions were that yes, the Data Practices Act does not apply to the judicial branch, and then the question is it fair to say do the public access rules play the same role for the judicial branch as the Data Practices Act does for other agencies? And the answer is yes, they do. Yes, please.
The terminology that you have there is public, confidential, or sealed. And then when you were talking about quoting, you talked about non-public. So that someone can freely quote from non-public. Does that include sealed?
So the question is the relationship between the terms confidential and sealed and the term non-public. The answer is non-public would encompass both confidential and sealed. And so there's no distinction in the rule for being able to quote from non-public documents between confidential documents and sealed documents. Do you have any questions on the webinar?
Not this time.
All right, then I will move on to the timing system. So those of you, if you practice in federal court, you will know that since 2009, the federal courts have used a simplified system of calculating rule-based deadlines. Under the federal system, all days, including weekends and holidays, are counted when calculating deadlines. And then if a deadline falls on a weekend or a holiday, the deadline continues to the next business day. Now, the system has worked out well for the federal courts, and so in 2016, the Minnesota State Bar Association filed a petition asking the Minnesota Supreme Court to make a similar, to enact a similar system in state courts. So the process for this was that the petition to have a new timing system was reviewed by several advisory committees, and the result is a new timing system in the rules of civil procedure, the general rules of practice for the district courts, and the rules of civil appellate procedure. The new system went into effect January 1st, 2020. And the question is, how does it apply to cases that, or does it apply to cases that were pending as of January 1st, 2020? And the answer is yes, it does. It applies to pending cases unless in a specific case the court makes a finding that the new deadlines would either not be feasible or that they would work an injustice. You'll notice rules of civil procedure, general rules of practice, rules of civil appellate procedure. That means the new timing system applies to civil cases, to family court cases at the district courts, and to cases before the appellate courts. The new timing system does not apply to criminal or juvenile cases before the district courts. Under the new state court timing system, to calculate a rule-based deadline, if the period is measured in days or a longer unit of time, you exclude the day of the event that triggers the period. You then count every day, including weekends and legal holidays. And then, as in the federal courts, if your deadline ends on a weekend or a legal holiday, you go to the next day that isn't a weekend or legal holiday. And most of these rule-based deadlines are now multiples of 7, so 7, 14, 21, or 28-day periods. One of the advantages of that system is that if a deadline, if the triggering event is on a Monday, then generally the deadline itself will also fall on a Monday, or it'll be the same day of the week. It's a lot simpler for people to calculate. For periods shorter than 7 days, and this is an important distinction, for periods shorter than 7 days, weekends and legal holidays are excluded from calculating if the specific rule that sets the deadline less than 7 days excludes weekends and legal holidays. And then for periods measured in hours, it's the same process. You count every hour, and if the end falls on weekend or legal holiday, continue to the next day that isn't a weekend or legal holiday. The rule also, the new system, we have concepts last days and next days. The last day of a debt, that's when the deadline ends. And the issue is this is an issue with electronic filing, when does the last day end? The last day ends at 11:59 p.m. local Minnesota time for e-filers. So one of the advantages, maybe not an advantage, but one of the impacts of e-filing was that attorneys had until 11:59 p.m. to file. It's not really a good idea to wait till the last day to file, and really not a good idea to wait till 11:59 p.m. to e-file. But as attorneys, as e-filers, they do have until 11:59 p.m. to e-file. However, you are governed by Minnesota's time zone. That's one of the things that we had to specify in the rules, since with e-filing, people from all over the country in different time zones can e-file in Minnesota state courts. And then for non-e-filers, so typically self-represented litigants, the last day ends when the court administrator's office is scheduled to close for the day. And then if you're determining what the next day is, remember, if the deadline ends on a weekend legal holiday, you go to the next day. You go by counting forward when the period is measured after an event, and by counting backward when the period is measured before an event. Another issue to be aware of is that the method of service, this is not new, it's been in the rules before, that the method of service can extend deadlines. So for deadlines that are triggered by the service of a document, such as a notice or a motion, many deadlines are triggered by service. If the document is served by mail, then the deadline is extended by 3 days. And if the document is served by means other than mail and is served after 5 p.m. local Minnesota time, the deadline is extended by 1 day. The reason for this is to reduce the incentives for gamesmanship. For whatever reason, lawyers seem to love to serve things at the very last minute. And so, the committee is discussing this. They said we can't eliminate gamesmanship, but we can structure the rules so as to reduce the incentive for gamesmanship. So if someone does, and typically this would be attorneys serving each other electronically, since that is required for attorneys, late into the evening, then the deadline, if it's after 5 p.m. local Minnesota time, the deadline to respond is extended by 1 day. Another area for clarification is what is a legal holiday? The definition of legal holiday was clarified to be days listed in state law as holidays for any statewide branch of government. Note that's holidays for any statewide branch of government. So courts are open on Columbus Day, but other branches of government do recognize Columbus Day as a holiday. See, I know that because I come to work on Columbus Day, but that would be for purposes of calculating deadlines. Columbus Day would be considered a legal holiday. And also days that the U.S. mail does not operate are considered legal holidays under the definition. One of the changes, some of the prior rules included, they said other federally and county designated holidays. Frankly, I'm not sure what counties designate holidays, but whatever impact that may have had in the past, they are no longer included as legal holidays. And just note, and this is taken from the statutory definition, if New Year's Day, July 4th, November 11th, or Christmas Day falls on a weekend, then the adjoining weekday is considered a holiday. I mentioned earlier, my first example was an untimely appeal. The appellate deadlines that the appellate courts have a practice, they tend to construe deadlines fairly strictly, and so it's in the appellate world, it's very important, as it is anywhere, to be aware of deadlines. In general, 20-day periods, prior 20-day periods have become 21-day periods. 10-day periods have become either a 7-day period or a 14-day period, and then 5-day periods become 7-day periods. You should consult the rules of civil appellate procedure to confirm the specific deadlines. I mentioned earlier the issue with periods less than 7 days, including weekends and holidays. Under the rules of civil appellate procedure, some 3-day periods include weekends and holidays, others do not. The timing system superseded the precedent of State v. Hugger for civil appeals, not for criminal appeals, but for civil appeals. Do we have any questions from the webinar or in the room on the timing system? I'm seeing no questions from, all right. When I've given CLEs about this, most people have said, the reaction I've gotten from audiences, yes, it's a lot of rule changes, but day-to-day impact is very little. Again, the purpose of the new timing system was simply to simplify the calculation, and our experience has been it truly has simplified calculation of deadlines. Oh, did it? Yes.
The question is, less than 7 days, does this include the 7th day? Would the rule then read on the 7th day or less? So clarifying what less than 7 days.
So the question is some clarification over less than 7 days. The standard is if a deadline is less than 7 days, then it would include weekends and holidays or exclude them based on the specific rule. But if it is 7 days, then it's calculated as the other deadlines. It's only less than 7 days are calculated differently. So now that I've talked with you about rules that are already in effect, I'll talk with you about some rules that are going to go into effect March 1st of this year, and those deal with transcripts of audio-visual exhibits. So the background to this is that in today's world, courts see videos from body cams, dash cams, smartphones all the time. Everyone really, I don't know how many of you in this room have cell phones. I'm going to assume it's almost all of you. I'm included in that group. Frankly, we all have the ability to record each other. Law enforcement, they routinely record their interactions with the public, and so quite often those videos are offered as evidence in court proceedings. And in practice, it's often difficult to discern what was said in these videos. Think about a law enforcement officer pulls someone over, it's middle of the night, side of the road, the wind is blowing, some rain is falling, and you got this little camera and a microphone on the law enforcement officer's chest. And so the court's looking at what's the interaction with this person pulled over for drunk driving. It's very difficult to discern what was said in these videos. And so our court reporters asked for some clarification of what was their obligation with respect to these audio-visual exhibits. Do they have an obligation to transcribe them? And so this was discussed by, there's a work group that discussed it. It was discussed by judicial counsel. It was discussed by the Supreme Court's advisory committees on the rules of civil appellate procedure and criminal procedure. And in all that discussion, there was one point of consensus, which is that court reporters are not finders of fact, and they do not resolve disputed questions about what was said on a video. That is for the finder of fact to determine. However, there was some confusion in practice as to what is a court reporter's obligation to transcribe an audiovisual exhibit. So first, the pre-March 1st, 2020 rules, so the rules that are still in effect. And I'll start by talking about what happens on an appeal. In civil appeals, court reporters, and this is in the rules of civil appellate procedure, court reporters are only required to transcribe audiovisual testimony, which would mean depositions either given on video or given on an audio recording. But court reporters are not required to transcribe audiovisual exhibits. And in criminal appeals, let's say there was a transcript offered by the proponent of the exhibit at the trial court, and the parties stipulate to the accuracy of that transcript, then the transcript becomes part of the record on appeal. If there is no such transcript under the current rules in criminal appeals, then the court reporter must transcribe the audiovisual exhibit. But unlike the other transcripts, the transcripts of the testimony, the court reporter is not required to certify that the transcript is accurate. And now with the set of rules, court reporters consistent around the state reported that there was still confusion over their obligations, and they also were very clear that in practice it is very, very difficult for a court reporter to transcribe a lot of these body cams and dash cam videos that they see. And so Supreme Court, I have them at the end of the handout, the two rules promulgation orders, so if you want to look at the specific language. But the Supreme Court has issued amendments that will go into effect March 1st of 2020. I'll start by talking about criminal cases at the trial courts. Under the new system, trial courts cannot require transcripts of audio-visual exhibits as a prerequisite to admissibility. I think that was the practice of some trial court judges, or in some courts I think have standing orders in criminal cases. And under the new set of rules, trial courts cannot require transcripts of audiovisual exhibits as a prerequisite to admissibility. However, parties can choose to offer illustrative transcripts of audiovisual exhibits. Now, illustrative transcripts, they don't replace the audiovisual exhibits, but they can be helpful to whether it's a judge or I think especially a jury navigating through the exhibit as it's being played in court. And the other significant change is in criminal cases at the trial courts, court reporters are prohibited from transcribing audiovisual exhibits, even if the parties or the judge want the court reporter to transcribe them. One of the issues that the judges raised when they were discussing this issue is that some of them liked to use these these transcripts as a way of assessing admissibility of an audiovisual exhibit, and as instead of listening to the entire exhibit, that it would aid the judge by reviewing, is there a mention of a prior conviction, or is there something that's otherwise inadmissible mentioned in the video. Now, that practice will no longer be allowed effective March 1st, 2020. However, the rules do not preclude district court judges from requiring proponents to demonstrate admissibility of audiovisual exhibits by other means. So, that might mean requiring the proponent of the exhibit to say, well, it's timestamp 1 minute 36 seconds until 2 minutes 47 seconds is admissible because of this reason. Then the other side could come back and say, well, no, it's not admissible for this specific reason. The burden, trial court judges can still require proponents to demonstrate admissibility of audiovisual exhibits. It's just that they can't require illustrative transcripts to assess admissibility. For civil cases in the trial courts under the new system, the rules amendments do not apply to civil cases at the trial courts. I mentioned smartphones. Given the prevalence of smartphones, other devices that can record video, audiovisual exhibits are not uncommon in civil cases. Where I think courts see it a lot, especially, is in family law, where custody exchanges, sometimes phone calls that people record each other, and then the judge gets to listen to that, or in order for protection cases. As in criminal cases, judges can require proponents of these exhibits to demonstrate why they are admissible. Issues such as relevance, cumulative nature, undue prejudice, etc., they continue to be within the discretion of the trial court judge. Then for cases on appeal, and this is both civil and criminal cases if they are appealed, if a case is appealed, then any audiovisual exhibits that were admitted and any illustrative transcripts that were admitted by the trial court, they become part of the record on appeal. And then the question is, let's say there is no such transcript. If no transcript of an audiovisual exhibit was admitted, then either party to the appeal can request a transcript. There will only be a transcript prepared if a party to the appeal requests one. The court reporter then has the option of either transcribing the exhibit or requiring the exhibit's proponent to provide a transcript to the court reporter within 30 days, which the court reporter may correct before filing. When I've given CLEs about this to external, so for those of you who are outside of the judicial branch, just keep in mind that if you offer an audiovisual exhibit, and let's say the case is appealed in the future, you may be in a position where you are required by the court reporter to prepare a transcript of the exhibit that you offered. And then again, as today, the court reporters need not certify transcripts of audiovisual exhibits. Certainly, if you've worked with audiovisual exhibits before, you'll know there are situations where it's just not clear what was said on the recording, and so the parties are free to dispute the accuracy of their audio of the transcript in their appellate briefs. Are there any questions about the new rules for audiovisual exhibits? All right, then I will move on to pending rules proposals. These are a set of rules proposals that are currently under consideration by the Minnesota Supreme Court. They were brought to the court at the request of the Minnesota State Court Administrator, who in turn was asked to bring these forward based on what we've heard from court staff from all over the state. And as you can see from reading the bullets, they all relate to public accessibility and confidentiality of court records, which is one of the questions that we got earlier on. And so the biggest change, and this is, again, this was proposed by the State Court Administrator. It was discussed by several of the court's advisory committees, and it was supported by those advisory committees. It would allow court administration staff to reject filings if the filer does not properly separate non-public documents or non-public information from those documents. And so that would currently, under Civil Procedure Rule 5.04, district court administration staff have very limited authority to reject filings. They can reject your filing if you don't pay your filing fee, which I believe is the most common, if you have filed into the wrong case, if you filed into the wrong court. Sometimes, yes, that does happen, or if you filed an unauthorized discovery response. And so the change would allow staff to reject your filings if you fail to properly separate. Usually it would be non-public documents. However, it would also include non-public information. I mentioned that filers in general can include quotes from non-public documents in their public court filings, but there are a couple of data elements that are non-public information, specifically restricted identifiers, and that's one of the other changes, which would be to clarify the definition of restricted identifier. Restricted identifiers are defined in General Rule of Practice 11 to include social security numbers, employer identification numbers, and financial account numbers. And this is not a new rule. It's been in place since, I believe, 2005, that all filers are prohibited from including restricted identifiers in their court filings. Reason for that is to prevent identity theft. So no social security numbers, employer identification numbers, or financial account numbers in public court filings. Where I think staff have reported the most confusion is in the area of financial account numbers. I think most of us by now, we know, be careful with people's social security numbers, but financial account numbers can also be used for identity theft. Think about it. Would you really want your credit card number or your checking account number in a public court filing for everyone to read? No, you would not, because you don't want your identity stolen. And so there's one of the rules proposals would clarify the definition of restricted identifier by, among other things, clarifying what is and is not a financial account number. Under the proposal, if court staff see when they're reviewing your filings that you have not separated non-public documents, or if you have included some non-public data elements such as restricted identifiers, then they can reject your filings. What that would mean for attorneys is you have not, if it's rejected, then you may have missed a filing date. At the minimum, you have to refile, and there's also the risk that you may have missed a filing date. You would also likely have to file a motion for relation back if you wanted to preserve your filing date. So that's the first part. If staff are reviewing your filings under these proposed rules, and if they see that you have not separated non-public documents, they can reject your filing. And then the second part would be to expand administrative striking of filings. Like I mentioned earlier, once something has been filed into a court file, it's there in the court file. Staff don't have the ability to claw it back. However, under the proposal, it would expand their authority to administratively strike the filing. It would mean under the proposal that if something's already been filed, so staff can't reject it, but then they see that there's some non-public information, staff would be authorized to strike your filing by, the way they do it would be to increase what's called the security classification, meaning, and this is what attorneys really care about, that judges cannot see your filing. So if the judge can't see it, the judge can't review it, there's a note in the file that it's been administratively stricken. You get not very nice notice from court administration saying that your filing has been stricken due to your failure to comply with your obligation to separate non-public documents. And under the proposal, you would only have 3 days within which to cure your filing. And so those are the two principal mechanisms the court administrator has asked the court to authorize for staff to have to address the issue of filers not separating out non-public information. As of this moment, they are under consideration by the Supreme Court. The third bullet, convert Form 11-2 to a cover sheet for all non-public documents. Those of you working in the district courts, you'll know Form 11-2 is a cover sheet currently only authorized for financial source documents. In practice, staff have noticed that people are using this as a cover sheet for all kinds of non-public documents, medical records, usually it's medical records, but any kind of non-public document. And now that's a technical violation of the rules, because under the current rules, it is only authorized, Form 11-2 is only authorized for financial source documents. However, the state court administrator has asked the Supreme Court to bless this practice by filers and just amend the rules to allow people to use Form 11-2 as a generic cover sheet for all non-public documents. Under the proposal, you would have two options for filing non-public documents. Either file them with the Form 11-2 cover sheet, or you can file them using a specific event code in the electronic filing system, filing code in the electronic filing system that is designed for specifically for non-public documents. So one example, the medical records filing code is, if you have a medical record, remember medical records are non-public, that is one of the filing codes specifically designed for non-public documents. Another one, second to last bullet, that when I've given this presentation, given this to a couple of family law bar sections, this one has raised a couple of eyebrows, but it is under consideration by the court. The proposal would make paternity cases public from their inception. So currently in Minnesota, paternity cases become public once there has been a final adjudication of paternity. And the rationale behind that, this is in the public access rules, rationale behind that was, under the statute, it says paternity cases should be non-public, but once paternity has been adjudicated, maybe there's some custody dispute that will be brought in the same paternity file. At that point, it should be public, just like any other custody dispute. And that's been the rule since 2015. In practice, in theory, it sounds pretty simple. Is there a final adjudication of paternity? In practice, it's been very difficult for staff to administer because the question is, what is a final adjudication of paternity? So it's gotten to the point where staff have had to ask for even some assistance from legal counsel division sometimes to determine what is or is not a final adjudication. And so this was discussed by the Supreme Court's Advisory Committee on the Rules of Public Access, and the committee agreed to recommend that paternity cases should be made public from their inception. So things like identities of alleged fathers, everything that is filed in the paternity case would become public under the proposal unless there's a specific reason why it would be non-public. Say, for example, if a medical record or a genetic test result were to be filed into a paternity case, then that would be continue to be non-public under the proposal. Another significant proposal before the Supreme Court, the last bullet, it would provide that medical records are non-public only if the filer designates them as non-public. And the reason for this is, we've gotten a lot of questions from court staff as what is a medical record? What isn't a medical record? Remember, the definition is that it has to be from a medical healthcare or a scientific or healthcare professional, and it has to relate to an individual's health. Well, in practice, drawing that line has been very difficult. There's some case law under the Health Records Act as well that drawing that line is in practice quite difficult. And so, for example, let's say you have an email from a therapist to parents discussing arrangements for the daughter to participate in therapy. Is that a medical record or not? Does it relate to the daughter's health, or does it just relate to the therapist's expectations with the parents for therapy? That's a real example of a situation that was determined, or a document that was determined not to be a medical record. And so under the proposal, it would, again, just like everything else with confidentiality, the burden is on the filer to separate non-public information from public court filings. Under the proposal, medical records would be non-public only if the filer designates them as non-public. Do you have any questions about the pending rules proposals? All right, we've got about 5 minutes left. I am going to move on to the last topic, what I refer to at start as service contact clutter. I think clutter really describes what we have on the screen. This is from a real case. I don't know if you can read the dates. It's January 17th of 2020. And this is an issue that staff have been reporting, court administration staff have been reporting for a few years now. And this is what happens when we have filers designating multiple service contacts. This is really more of an issue for external filers to be aware of. It's something for court administration staff to be aware of as well. If you can see in the upper left-hand corner, there was one document filed on January 17th of 2020, and what got blacked out underneath that, go all the way down to the bottom of the column, all the way onto the next one. Those are, if you count them, there are 31 separate entries in the Register of Actions of that document being served on the 31 separate email addresses that the parties to the case had listed as service contacts. Now, this was a big case, and there were multiple parties, multiple law firms, but then the multiple law firms had listed, I think it was between 3 and 9 separate email addresses for receipt of service. It creates a very messy Register of Actions. At the time I took the screenshot, the Register of Actions was 226 pages long. More importantly, it's really, someone said gosh, so it's not not a good thing. And more importantly, it creates very serious performance issues from MNCIS. So when court administration staff are trying to access the case and update, file documents into the case, or judges are trying to look at the case, or Minnesota Public Access, that system is also affected by this. And so this is what can happen when filers designate multiple service contacts. This particular case was resolved. The judge issued an order directing the filers. You can only have one service contact per party, and also directed state court administration to archive the service events, so remove them from displaying in this way in the public register of actions and put them into it's a PDF that has all the information about service. After that process was completed, the register of actions went from 226 pages down to 9 pages. So think about that. Well over 200 pages of the register of actions were just service entries. So I talk about this a lot more detail with external filers because it applies to them, but for court administration staff to be aware, court employees to be aware of, filers are required at the district court to designate an email address for receipt of service in each individual case, and that's based on General Rule of Practice 1402. And this is different from the appellate courts, where the appellate court will add you as a service contact to a case. At the district court, filers are required to designate a single email address for receipt of service. However, it does not have to be the filer's main work email address. And also, I remind external filers, service contact emails, they are public records. Some people don't want their personal email address in the public court record. And so where this usually happens, I think, is, we'll have an attorney, and then maybe there's a senior partner who wants to get CC'd, and then there's the paralegal and the administrative assistant. And so law firms may want to have multiple people be served with documents when they're filed. To do that without cluttering up the service, the register of actions, we advise external filers they can use either group email address or the EFS administrative copy feature to send to multiple recipients, and that avoids cluttering up the court record with unnecessary service entries. Case that I showed you, it was an extreme example, but it's not the only example where this issue has been a burden on court administration staff and has also interfered with public access to court records. Another reminder I have, and this has been prohibited in court rules for several years at the district courts, attorneys are not allowed to designate service contacts for other parties. The purpose for that is to ensure that people are getting served at the email address they want to be served at. Every once in a while, people will try to designate service contacts for other parties. That is strictly prohibited under court rules. So that is all I have for you. I think we're just about at time. If any of you have questions, I do see a question. So the question is the EFS administrative copies feature the same as the courtesy copies? Answer is no, it is not. Courtesy copies is designed typically if an attorney, you're filing something, you want to send something to your client as well, a courtesy copy. Administrative copies is a separate feature within EFS, and then you have that set up. Everyone listed in the administrative copies will get a copy of whatever is served on you without it going into the register of actions. Any questions from the webinar?
Yes. One asking, isn't it problematic to tell clerks and attorneys that they are responsible for making sure they are filing on time and aware of filings, and then also decrying having a multitude of service contacts?
So the question is problematic about making sure that people are filing on time while also not wanting to have multiple service contacts. What I would recommend in that case is to use either the group email addresses or the administrative copy feature. That's what those features are designed for, specifically so that filers can, if you need to have multiple people in the law firm, get copies of filings or filings that have been served on you without cluttering up the service record. Well, I don't see any other hands. It is a little bit past time, so I'll just say thank you to all of you for coming today. If any of you want to come up afterwards with questions, I'm happy to take them.